July 4th, 2025, President Trump signed the One Big Beautiful Bill into law. And buried inside that massive budget legislation was something gun owners have been fighting for since 1934. The $200 NFA tax stamp was reduced to $0 for suppressors, short-barreled rifles, short-barreled shotguns, and any other weapons. Starting January 1st, 2026, just weeks away, you won't pay $200 anymore to buy a suppressor or SBR. It's free, but here's what nobody is telling you. Gun Owners of America, Silencer Shop, Palmetto State Armory, and 15 states immediately filed lawsuits arguing that once the tax is gone, the entire NFA registry is unconstitutional. No more fingerprints. No more ATF approval. No more waiting months for permission. The Trump Department of Justice just filed their response. And shockingly, they're defending the NFA, arguing the registry should stay even with a $0 tax. This is the biggest battle over suppressors and SBRs in 90 years. And what happens in this courtroom will determine whether you need government permission to own these items, or whether you can buy them like any other firearm. Let me show you exactly what's at stake. To understand this fight, you need to know what changed on July 4th, 2025. The National Firearms Act was passed in 1934 during the gangster era. It imposed a $200 tax on certain firearms, machine guns, suppressors, short-barreled rifles, SBRs, short-barreled shotguns, SBSs, and any other weapons, AOW. In 1934, $200 was massive, equivalent to about $4,600 today. The whole point was to price these items out of reach for ordinary Americans. For 90 years, that $200 tax stayed in place. If you wanted to buy a suppressor or build an SBR, you had to pay $200 tax. Submit fingerprints, provide passport photo, fill out ATF Form 4 or Form 1. Wait 6 to 12 months for approval, register your item. With the federal government, gun rights groups have been trying to repeal the NFA for decades. The Hearing Protection Act, HPA, would have removed suppressors entirely. The Short Act would have removed SBRs and SBSs. Neither passed. But in 2025, Republicans controlled Congress, and the White House Representative Andrew Clyde of Georgia, a gun store owner, himself pushed hard to include NFA repeal in the budget reconciliation bill. The House passed language fully removing suppressors, SBRs, SBSs, and AOWs from the NFA. It was a massive victory, but then the Senate parliamentarian and unelected bureaucrat named Elizabeth McDonough ruled that full repeal violated reconciliation rules because it wasn't purely about taxes and spending. So Republicans compromised. Reduce the tax to $0 but keep the registration system. The Senate passed it 51-50, with VP J.D. Vance casting the tie-breaking vote. President Trump signed it July 4th, 2025. What changed? Starting January 1st, 2026, $0 tax for suppressors. SBRs, SBSs, AOW, registry, fingerprints, photos, ATF approval still required. Machine guns and destructive devices not included, still $200 tax. Gun owners were furious. We wanted full repeal, not just a free tax stamp. But here's where it gets interesting. Gun Owners of America immediately announced they were filing the One Big Beautiful lawsuit to finish the job. Within hours of President Trump signing the bill, Gun Owners of America filed suit in U.S. District Court for the Northern District of Texas. The lawsuit is officially called Silencer Shop Foundation v. Bureau of Alcohol, Tobacco, Firearms, and Explosives. But GOA nicknamed it the One Big Beautiful lawsuit. Plaintiffs, massive coalition. Gun Owners of America, Silencer Shop Foundation, Silencer Co., major suppressor manufacturer, Palmetto State Armory, PSAB, and TUSA Firearms. Regulatory Accountability Coalition, 15 states, joined as co-plaintiffs supporting gun owners. So what actually happens on January 1st, 2026 while this lawsuit plays out? For consumers, starting January 1st, 2026, nitrogen monoxide, $200 tax stamp payment required for suppressors, SBRs, SBSs, AOWs, ATF, E-Form 4 and E-Form 1. Submissions are free background check still. Required fingerprints still, required passport photo still. Required wait time still. 6 to 12 months, possibly longer due to surge in applications. You're still registering your item with the federal government. You're just not paying $200 anymore. The surge is coming. Industry experts predict a massive surge in NFA applications starting January 1st. People who were on the fence about paying $200 will now submit forms. Silencer Shop CEO Brandon Maddox estimates applications could double or triple. That means wait times might increase despite $0 tax. State laws still apply. Here's a critical point. Even if the NFA is struck down in court, about 16 states have their own laws banning suppressors unless they're registered under the NFA. If the NFA disappears, those states would have to pass new laws legalizing suppressors. Some blue states like California, New York, and New Jersey might choose to keep them illegal, Brandon Maddox said. Some blue states are saying, if the NFA goes away, then we'll make them illegal here. So even if Go Away wins, the fight isn't over. You'll need state-level battles too. The GOA lawsuit isn't the only one. Multiple gun rights groups have filed similar challenges. NRA, ASA-FPC, SAF joint lawsuit, the National Rifle Association, American Suppressor Association, Firearms Policy Coalition, and Second Amendment Foundation filed their own lawsuit making similar arguments. In a joint statement, they said the $0 tax serves as a critical step towards our ultimate goal of dismantling the NFA once and for all. Why multiple lawsuits? Different groups filing in different courts creates multiple chances for success. If one court strikes down the NFA, it creates precedent for others. It also prevents the DOJ from focusing all resources on defeating one lawsuit. Supreme Court history. The Supreme Court has TWICE in recent years declined to hear NFA challenges. In 2024, SCOTUS denied review of 2 SBR cases, but those cases didn't have the $0 tax angle. GOA argues this is different because Congress itself undermined the constitutional justification by eliminating the tax. Timeline. The Northern District of Texas case is moving toward a summary judgment decision. Both sides have filed their motions. The judge could rule soon, possibly Q1 or Q2 2026. If the judge rules for gun owners, ATF would likely appeal to the Fifth Circuit Court of Appeals. That could take another year. If the Fifth Circuit rules for gun owners, DOJ would appeal to Supreme Court. Decision could come 2027 to 22/8. If gun owners lose at district court, they appeal. Same timeline. Bottom line. This will take years to fully resolve. So what should you do right now if you're interested in suppressors or SBRs? Action number 1. Decide if you want to file now or WAT starting January 1st, 2026. You can file for free, but you're still registering with a TF. Option A. File now, get your suppressor SBR approved under current system free tax stamp on legally regardless of lawsuit outcome. Option B. Wait for lawsuit, hope GOA wins and NFA is struck down by suppressor BR, like regular firearm, no registration RASK. Lawsuit could take years. You don't get item in meantime. Most gun owners will probably file starting January 1st because it's free and there's no guarantee the lawsuit succeeds. Action number 2. Check your state AOWs. If NFA falls, your state might ban suppressors or SBRs. Check current law. Is suppressor ownership legal in your state? Are there restrictions on SBRs? Does your state require registration? Don't assume federal changes mean state legality. Action number 3. Support gun rights organizations. These lawsuits, BOE, NRA, FPC, SAF, and others need funding. Even $10 a month helps. Action number 4. Prepare for long wait times. If you file January 1st, expect 12+ months for approval. ATF is already slow. The surge of free applications will overwhelm them. Action number 5. Follow the CACZ. Northern District of Texas case, Silencer Shop Foundation v. ATF, is the main one to watch. Case number 625CV00123 in Northern District of Texas, San Angelo Division. Court decisions are public. You can track it on PACER, Federal Court Database, or through gun rights organization updates. The legal argument, GOA argues that in 1937, the Supreme Court upheld the NFA only as a tax law in a case called Sinzinski v. United States. The court said Congress has the power to tax, and the NFA was a valid exercise of that taxing power. But here's the catch. The registration, fingerprinting, and approval requirements were justified as necessary to enforce the tax. You had to prove you paid the $200 before receiving your suppressor. Now that the tax is $0, GOA argues there's no constitutional basis for the registration system. Congress can't force you to register firearms when there's no tax to collect. The NFA no longer imposes any tax on the vast majority of firearms it purports to regulate, the lawsuit states. Once the tax is reduced to $0, the constitutional justification for the law collapses. What GOA wants the court to do? Declare that NFA registration and transfer requirements for untaxed items, suppressors, SBRs, SBSs, AOWs, exceed Congress's constitutional authority, block ATF from enforcing NFA regulations on these items, essentially, treat suppressors and SBRs like regular firearms, background check through NICS, then you walk out with it. No months-long wait. No federal registry. Eric Pratt, Senior VP of GOA, sighed. This is a once-in-a-generation opportunity to dismantle one of the most abusive federal gun control laws on the books. With the tax struck down by Congress, the rest of the NFA is standing on air. Now here's where things get controversial. On November 21, 2025, the Trump Department of Justice filed a response defending the NFA Attorney General. Pam Bondi, appointed by President Trump, signed off on the brief. The DOJ argues that even with a $0 tax, the NFA registration system is still constitutional. Gun owners are furious. Many are calling this a betrayal. One headline read, Trump's DOJ defends NFA registration, betraying gun owners. Let me break down the DOJ's three main arguments. Argument. #1. The special occupational tax still exists, the DOJ says. Yes. The $200 transfer tax is now $0, but the NFA still imposes a special occupational tax on manufacturers, importers, and dealers of NFA items. This is a business license tax. FFLs who make or sell suppressors pay an annual tax. The DOJ argues that the registration system helps enforce that tax. The challenged NFA requirements support the enforcement and collection of that remaining tax, the brief states. GOS response. This makes no sense. The occupational tax is a flat business fee unrelated to individual firearms. The fingerprinting, photo, and registration requirements for consumers have nothing to do with collecting taxes from businesses. Argument number 2. The Commerce Clause justifies. On NFA, the DOJ argues that Congress has the power to regulate interstate commerce. Most suppressors and SBRs are manufactured in one state and sold in another. That's interstate commerce. The NFA regulates the interstate market for SBRs, suppressors, and AOW, as the brief states. Most NFA firearms are manufactured and sold through interstate commerce. The DOJ even cites Gonzalez v. Raich, 2005a, medical marijuana case arguing that even intrastate activity, like making your own suppressor at home, affects interstate markets and can be regulated. GOA's response. The NFA was never structured as an interstate commerce law. It was always justified as a TAX law. The government can't just switch justifications now that the tax is gone. Plus, the Commerce Clause doesn't give Congress unlimited power. Forcing registration of items that never cross state lines exceeds federal authority. Argument. #3. The NFA doesn't violate the Second Amendment. DOJ relies heavily on a 2024 Fifth Circuit case called U.S. v. Peterson. In that case, the court ruled that the NFA operates like a shall issue licensing system similar to concealed carry permits. Under Bruin, shall issue systems are constitutional. If you meet the requirements, the government must approve you. No discretion. The DOJ argues the NFA is a shall issue system. If you pass the background check and submit the paperwork, ATF approves you. It's not a ban, it's a licensing scheme. GOA's response. This is absurd. Concealed carry permits take days or weeks. NFA Adams takes 612 months. And the comparison fails because carry permits don't create a federal registry of every gun you own. Plus, Brune requires historical precedent for gun restrictions. There's nitrogen monoxide historical tradition of fingerprinting, photographing, and registering firearms in a national database, but DOJ isn't fighting alone. 15 states have joined as co-plaintiffs supporting the lawsuit. Alaska, Arkansas, Idaho, Indiana, Iowa, Kansas, Louisiana, Mississippi, Missouri, Montana, North Dakota, South Carolina, South Dakota, Texas, and West Virginia. These states filed a brief arguing that the NFA violates federalism, the principle that states, not the federal government, have police power to regulate public safety. The NFA represents federal overreach into areas traditionally reserved to the states, the states argue. Regulation of firearms possession within state borders is a core state function. They point out that Congress doesn't have a general public safety power. The Constitution limits federal authority to specific enumerated powers like taxation and interstate commerce. However laudable these crime-fighting ends, there is no better example of police power which the founders denied the national government and reposed in the states. The state's brief states, "This is huge. When 15 states formally join a lawsuit, it signals serious constitutional concerns. This case is about more than just suppressors and SBRs. It's about the limits of federal power. The federalism question. The Constitution grants Congress specific powers. Everything else belongs to the states for 90 years. The NFA was justified as a tax. Court said Congress has the power to tax. So this is constitutional. But now that the tax is gone, what's the justification? The DOJ is scrambling to find new justifications. Commerce Clause, Public Safety, Business Licensing. GOA argues, if Congress can regulate firearms without taxing them, what can't they regulate? Healthcare? Education? Local crime? This case will help define the boundaries of federal authority in the post-Brune era. The registry. Question. Gun owners hate the NFA Registry. It's a federal database of who owns what firearms. If the government knows you own a suppressor or SBR, they know where it is if they ever decide to confiscate it. The Second Amendment protects the right to keep and bear arms. But does it protect the right to anonymity? To own firearms without government tracking? This case will address that question. The Brune Standard. Every gun case now goes through Brune's text. History and tradition. Test. Is there a historical tradition of fingerprinting and photographing gun owners? No. Is there a historical tradition of federal firearms registries? No. The founders would have been horrified by the NFA, yet courts have upheld it for 90 years as a tax. Now that excuse is gone, and Brune gives courts the tools to strike it down.